The reason we need reform in the area of eminent domain is because the laws are terribly skewed in favor of the condemning authorities. For anybody that's ever been subject to a taking, for any attorney that's ever practiced in this area, I think that's the first thing you see when you go into the courthouse, is the laws are skewed. Courts for years have treated private property as a second-class right. Meanwhile, legislators have chipped away at the right to private property, and they've granted vast powers to almost limitless numbers of entities who now have the power to take private property from individuals. Many of these entities are unelected and unaccountable. One of the speakers earlier said, if you're forced to move, you can't vote the takers out of office. Well, I would submit many of these takings are done by unelected, unaccountable bureaucrats. So even if you stayed, you can't vote them out of office. In Virginia, even the Mosquito Control Commission has the power to take a person's property. Stadium authorities have the ability to take an individual's property. We've gotten to a place in our courts where the courts have said public use means something different than use. We've gotten to a place where we have a constitution that guarantees just compensation, but our laws and our court opinions guarantee that an owner can never receive just compensation unless and only if the condemning authority benevolently makes a fair offer. There's one process called quick take that I think most citizens are not familiar with. Quick take is yet another example of how skewed the laws are. Many of you here today may be surprised to know that in Virginia and almost every other state around the nation, the government can go to the courthouse, and in Virginia, they don't even have to tell you when they're doing it. They just send you a letter and say, sometime in the future, we're going to take your property. It may be tomorrow, may be next year, it may be 3 years. The government can then go to the courthouse and file a certificate in the courthouse, and all they have to do is deposit what they believe to be the value of your property, and they instantly get title and ownership to your property. They can evict you. That's called the quick take power. It's unbelievable to me that that's become accepted and commonplace in this country. We also have the issue of litigation expenses. I said earlier that the laws make it clear that an owner cannot receive just compensation unless they receive a fair offer. And the reason is simple. There's a very easy example. If you take a homeowner whose property is worth $100,000 and the government offers them $50,000, and that owner goes to court and proves that his or her home was worth $100,000, but they had to spend $20,000 to do it, that owner now goes home with $80,000 for a $100,000 home. If the government doesn't make a fair and reasonable offer, why shouldn't it have to reimburse the owner? How can we say we fulfilled the mandate of just compensation if the owner is not justly compensated? We have another area. The Landowner's Bill of Rights, as we've called it. The Virginia Institute for Public Policy has a study that's out on the table, and they were instrumental in pushing for a constitutional amendment in Virginia. They were the first organization that I was aware of that was pushing for a constitutional amendment, ironically, even before Kelo in Virginia. And they have a study, and it talks in there about Virginia's Bill of Rights. But there's also a federal statute under the Uniform Relocation Act that sometimes is referred to as the Landowner's Bill of Rights. What's so interesting about that is that statute gives all these rights to landowners, and then at the end it says it creates no rights or liabilities. Just last year, the Fourth Circuit Court of Appeals ruled that that statute, the federal statute, creates no rights. So we have a statute giving landowners all these rights that creates no rights. And to that, I submit to the legislature, why bother? What's the purpose of that? In Virginia, owners are treated like criminals. And I say that because the owners in Virginia bear the burdens of plaintiffs. They have the burden of proof, but yet they're put in the position of defendants. The government gets to speak first, and the government gets to speak last, which is typically what the plaintiff gets to do. The owner doesn't get that right in Virginia, yet the owner bears the burden of the plaintiff. And most importantly is an issue of the right to a jury. In federal court, owners have no right to a jury. So the government can take your property. An individual judge on his own or her own can say, I'm not giving the owner a right to a jury, and can appoint whatever 3 people that judge wants. And that's happened time and time again in our cases, where we go in federal court, we request a jury, the judge says no, and then the judge appoints 3 people. Sometimes it's the judge's cronies that you have on there. There's a challenge right now. I think it's Errant Fox is the name of the law firm, and Thor Hearn is the attorney. He's challenging right now in Michigan the lack of a right to a jury in eminent domain cases for property owners. But I lay that out there to tell you the laws aren't fair. And anybody that disputes that, I would welcome you to come to court with me for a week. You'll see it right away. And I think in the area of eminent domain, the famous warning of President Reagan rings most true, that the 9 most terrifying words in the English language are, "I'm from the government and I'm here to help." Because when you get that knock on the door, you're facing an uphill battle when it comes to eminent domain. Earlier, Mr. Pallon mentioned regulatory takings. We have a case right now that we're seeking an appeal in the Virginia Supreme Court, where we had a local airport that started flying planes very low over a neighborhood, rattling homes, causing noise, preventing people from sleeping, windows falling off of some of the homes. And the judge in that case said that when the zoning ordinance was passed in 1999 that restricted how high owners could build their homes or how high they could maintain trees, he said that zoning ordinance gave the public a right to fly through those owners' property. So that judge interpreted a zoning ordinance as giving the public a right to use somebody's property. It just shows how absurd some of these rulings can get. We have another ruling that's pending where the court held that an easement is not compensable. So to put that in basic terms, if you have a home that's on one parcel and your driveway is through the adjacent parcel and your driveway is an easement that allows you to get to the home, in that court, the judge said if the government takes your easement, no compensation is due. And these are the types of opinions that we see time and time again. We just had an opinion from the Virginia Supreme Court that came out in April. It was a trial I had in the lower court where the government had come to my client and said, your property is worth $500,000 and made an offer. When we got to trial, the government showed up and said, no, it's really only worth $250,000. And by the way, that money we deposited into court, you need to pay it back to us, even though they had already taken the property and already built their road on my client's property. What happened in that case is the trial judge did exactly what judges have done for years in Virginia, and he said it would be unfairly prejudicial. And some other reasons, he gave some other reasons, but he said, you can't tell the jury what the government told you before. You can't tell the jury the government told you your home was worth $500,000. We got a unanimous decision out of the Virginia Supreme Court in April reversing that. And now in Virginia, if the government does a bait and switch, if they try to play fast and loose, at least now the jury can hear all the evidence. And so that leads me into the types of reform. When you hear about all this and you hear about these decisions and these laws, the first thing I think of is the legislature has failed us miserably. So you have 2 types of reform, constitutional or legislative. Legislative reform is fleeting. What the legislature gives today, they can take away tomorrow. But when the people speak and when the people enact a constitutional amendment, it has permanence. And I think it was Mark Twain that said nobody's rights are secure when the legislature is in session. And it was that very reason that drove Virginians to move for a constitutional amendment, to not be satisfied with legislative reform. And we went one step further in Virginia, and I'm hoping that other states are going to do likewise, and I think we're going to see a trend of litigation over the rights to a jury, litigation over just compensation, which is that second protection. But Virginia addressed not only the public use clause, but if you look at our Constitution now, it also addressed some of the just compensation issues. Some of the bright line rules that kept Virginians from being justly compensated were removed by our constitutional amendment, where now at least Virginians have a fighting chance to be made whole. And you may ask yourself, how did we get to this point? How are the laws so skewed? Why? And those on the other side would say I'm biased, and to them I say the facts are the facts. You can read the statutes. They speak for themselves. How did we get statutes that were so lopsided? It's very simple. It's the takers' lobby or the condemning authorities' lobby. While the individual is busy working, busy paying their taxes, we have an army of government lobbyists that are down at the legislature year after year after year, and Richmond is a prime example of it. And the most perverse aspect of this practice is that these government-funded lobbyists are forcing property owners to fund the demise of their own property rights. What happens in Virginia, because government-funded lobbyists are permitted there, the local governments, they will tax owners, they'll tax their property and turn around and use that tax money to hire lobbyists to go down to Richmond and strip them of their property rights. And it's really a perverse practice. The other thing that we see are misleading fiscal impact statements. Anytime there's legislative reform that's proposed, you hear the outcry that the sky is falling, this will prohibit development, prohibit growth. And those fiscal impact statements are misleading. And I say that because the cost of the project is what it is. If you have a project where the land acquisition costs $100,000, the building costs $100,000, and there's going to be $100,000 of damage inflicted to the property, whether that's putting a business out of business or just simply damage from a partial taking, the cost is $300,000. The only thing that changes is who pays for it. When the government chooses not to pay damages, it doesn't mean that cost isn't there. It just means we're putting that cost disproportionately on the back of the individual owner who has to surrender his or her property. So I submit there are two foundational changes that can help achieve reform. The first is to prohibit government-funded lobbyists. That's largely what put us where we are today. And second is I think we need to record votes at all levels, in subcommittee, in committee, and on the floor. And if you look at Virginia's vote on the constitutional amendment, what's very interesting, there were many legislators that voted against it, even on the floor, the first vote. But when it became clear that it was going to pass, it was unanimous. And they all now tout that they voted for it. Yet, when you look at the truth and you look at the facts, there were many that didn't. And I'll end with some final thoughts that private property is truly a bipartisan issue. So anybody seeking reform, I would encourage you to seek support in all camps. As Gideon Cantor, a champion of property rights, once said, in his opinion, Democrats don't want private property and Republicans don't want to pay for it, is his analysis. And there's some truth to that, but there's also truth in we find people on both sides of the fence that are willing to support private property rights.